Hi, I'm Ryan Mullally, and this is Natural Law. Today, I'm going to try to explain to you why originalism is not the boogeyman. And if you love originalism, you probably don't need convincing, but maybe video will be of value to you anyway. And if you're not an originalist, hopefully there's something of value for you as well, even if it's just learning to sharpen your knives so that you can make even better arguments against originalism in the future. My goal here is to present originalism in layperson's terms. I'm going to try to avoid legal abstraction and explain why originalism is, in my opinion, the best method of constitutional interpretation and the method that best protects our Constitution, our federalism, our constitutional values, and most importantly, on some level, our democracy. That's what I'm here to do today. I'm going to make the case that originalism is not the boogeyman, and you can let me know how I did. In some ways, I'm a bit of a strange messenger for originalism. If you followed any of my content, you know that I spent most of my life identifying as left-leaning and voting for left-leaning political projects. These days, I identify as a centrist, but as you can probably expect, originalism was a surprise for me. I became an originalist in law school when I was exposed to the arguments in favor of it, and I found them convincing. But it was in great tension. It didn't support my political projects, and it took me a while to reconcile the tension between my admiration for these arguments and the fact that it didn't line up with what I thought the Constitution ought to be and how law ought to be prior to law school. A little background about me, in case you don't know. I was a Teach for America Corps member. Like many Teach for America Corps members, I joined specifically for what's now known as social justice reasons. I thought there were people, particularly in communities that I knew well, that had been dealt a bad hand. And I thought that a great education, coming in there and doing my best, being the best teacher I could be, would make a difference in those communities. And I worked as a teacher for 7 years in New York City public schools before I went to law school. I did well in law school, graduated, went to a great law firm, and then after a few years became a law clerk in the Southern District of New York. For those of you who are unfamiliar, law clerks are lawyers who then help a judge manage their docket. We draft orders, we draft opinions, we do legal research, we help the judge at trial, we help manage the judge's workload. And this is a wonderful experience for young lawyers because you get to learn how the sausage is made. You get to see how judges really decide cases, and you get to work with an extraordinary lawyer who's risen to such a prominent place in our legal order. It's finishing school for lawyers, basically. So I did that. My term was 1 year, and then I went back into private practice. And I've litigated at pretty much every level of our U.S. system, from arbitration to state courts to U.S. district courts, all the way to the U.S. Supreme Court. Long and the short of it is, I think my educational background and my legal background give me a unique perspective and hopefully give me the background and skills necessary to provide you with something of value that you can take with you, and whether you are originalist or not, use it to discuss originalism with more nuance and depth and sophistication. So, if originalism is considered the boogeyman, Justice Antonin Scalia is the boogeyman himself. Rest in peace, Justice Scalia. Justice Scalia is considered the boogeyman because he popularized originalism. You can differ about the year, but prior to somewhere between 1940 and 1960, originalism was essentially the only method of constitutional interpretation. Most Supreme Court justices would be considered originalists by today's standards. However, in the middle of the 1900s, a new school of constitutional interpretation, which is now called living constitutionalism, became quite popular, and judges and justices started interpreting the Constitution in new, more flexible ways. We're going to discuss living constitutionalism later, but enter Justice Scalia. He's famed for his wit, famed for his clear, concise, and often humorous writing style, and he moved the needle. He was the one who repopularized and re-energized originalism and made it into the dominant force in U.S. jurisprudence that it is today. And this is one of my favorite quotes from Justice Scalia. It, I think, points at what originalism is and why he believed in it and why I believe in it. So he said, a freedom-loving people respectful of the rule of law may be expected to let lawyers decide what a constitutional text means. Lawyers, and judges are lawyers, use legal reasoning. We look at legal documents, we look at contracts, we look at laws, we look at the Constitution, and we interpret them using legal reasoning. That is what lawyers do. That's lawyers' work. But lawyers cannot be expected, but the people cannot be expected to let lawyers decide what a Constitution ought to say. Why not? Because that is not a job for lawyers, but for the people. The people, through their elected representatives, decided what the Constitution should say. The people, through their elected representatives, say what the law is. That's what the Senate does. That's what the president, when he vetoes or signs a law, contributes to, the creation of law. And when the Constitution is amended or when it was ratified originally, that was done by the representatives of the people, not lawyers interpreting it years later. His concern is the preservation of democracy. He wants to ensure that the rules that the people approved are the rules that we're following, not what judges decades later think. Now, not everyone agrees with that. Here is the boogeyman's dear friend, Justice Ruth Bader Ginsburg, also rest in peace. She was a true icon of the left, the liberal lion on the court in her time, and perhaps the lawyer most associated with women's rights in this country. And she wrote of Justice Scalia in the foreword she authored for a book called Scalia Speaks, which is a collection of his public remarks published posthumously. If our friendship encourages others to appreciate that some very good people have ideas with which we disagree, and that despite differences, people of goodwill can pull together for the well-being of the institutions we serve and our country, I'll be overjoyed, as I am confident Justice Scalia would be. Justice Scalia and Justice Ginsburg disagreed on just about everything. They had different values. They had a different method for interpreting the Constitution. Their opinions were often at odds and clashed, but they were dear friends. They went to the opera together. They went to the opera together so much that there's famously an opera called Scalia-Ginsburg, or it might be Ginsburg-Scalia, I can't quite recall. But there's an opera written about how often they go to the opera because their friendship was so remarkable. And this is an important point. Judicial philosophy is an idea. I think originalism is the right idea. You might agree with me, you might not. But people can have good reasons and good faith reasons to be an originalist or be a living constitutionalist. Someone disagreeing with you does not mean that they're bad faith. The issue is the quality of the ideas. I'm going to present originalism today and explain it to you in simple terms and hopefully convincing terms. And maybe you'll agree with me, maybe you won't. But I hope that even if you disagree with me, you'll come to understand that originalism is a principled school of thought that can be defended in good faith, and that this is not the issue that needs to tear our country apart, though if you go online, you might think it is. So why are people so mad about originalism? Why was I so mad about originalism prior to law school? Why does my family still get upset at me when I defend originalism despite my best efforts? And if I can't convince them, maybe I can't convince you. So we'll see how this goes. Well, the answer is that people judge legal outcomes based on their results, which is, for reasons I'm going to explain, inappropriate. When you elect a politician, a senator, a president, they make campaign promises. They say, I'm going to lower taxes, or I'm going to increase your quality of living by passing a child tax credit. They promise things, and when you elect them, you want that result. That's why you elected them. So you judge them by the outcome, by the result. And that's totally fair for an elected politician. That is not a good way to judge a court or a judge. In the legal world, there's a cycle. There are inputs People come to court. They say, this is what happened. I plead this fact. I was injured in this way. Later on, they're given the chance to provide evidence. Witnesses testify. Documents are presented. Experts come in. Then the lawyers also make arguments. They say, this is the law. No, this is the law. The court should interpret it this way. This is the right out. This is the way the law should work. And all of that input goes to the judge, and in a jury trial, the jury as well. And the court engages in legal reasoning. It analyzes the cases presented. It looks at the evidence, or the jury looks at the evidence in a jury trial, and comes to legal conclusions based on legal reasoning, and that leads to a result. But you can't judge the court by the result it reaches. Courts are not outcome determinative in that way. A great example of this is the Kyle Rittenhouse case, which is very famous. If you're unfamiliar, Mr. Rittenhouse was charged with murder and asserted a self-defense as his defense. He was ultimately acquitted on that basis. The jury found that he was acting in self-defense. A lot of people were very mad about this result because they didn't like it. They thought he should have been guilty. A lot of people were very happy about this result because they thought he was innocent and they're glad the court did what they wanted. But you can't, both groups of people are wrong, not because of their political preferences, but because judging a court on whether or not it does what you want is not the right way to judge a court. You judge a court on whether it followed the law, whether it accurately interpreted the law, whether its process was fair, whether it was impartial, whether it gave both sides due process. This is how you judge a court. Judging a court whether it does what you want is insane. Why would we even bother having courts if the whole point is just to do what you want? You don't decide the outcome. The law does. Courts must be evaluated on their process. And the point I'm going to be making today is that originalism is a good process. In fact, the best process for constitutional interpretation. So here is my imperfect analogy, and I'm going to take a sip of my little beverage. I've been talking for a while. It is an imperfect analogy, so if you must tell me this is an imperfect analogy in the comments, feel free. I'm just going to point you back to the title of this slide. Imagine you're watching a baseball game. It's the middle of the season. It's like game 90-something. Now, the batter comes up. First pitch, swing and a miss, strike one. Second pitch, swing and a miss, strike two. Third pitch, swing and a miss, strike three. The umpire exclaims, "You're out." That's baseball. 3 strikes, you're out. We all know the rules. Now imagine, though obviously this would never happen, but imagine the batter turns to the umpire and says, "Hey, umpire, I know I got 3 strikes, and I know that you said you're out, but can we talk for a second about the 3-strike rule?" We live in an evolving society. Our norms are changing. We value inclusivity. We want people of all abilities to get to play baseball. Moreover, we know that hits are what people like. People like to see hits. They like to see scoring. They like to see a more active game. 3 strikes, you're out is an archaic rule. It doesn't honor inclusivity, and it doesn't honor what people like, which is hits and high scores. 4 strikes is a better rule. So can I get 1 more strike? Let's change the rule. I should get 4 strikes, and we can do 4 strikes going forward. Obviously, this is a kind of silly example, but the reason I bring it up is that you're going to have a gut reaction to this. Now, maybe, though I don't think I did the best job convincing you, but maybe some of you think, God, yeah, that would be better. 4 strikes would be better. And maybe even the argument that Ryan just gave isn't that good. Maybe there's a better argument for 4 strikes. And I like that argument better. But for whatever the reason is, I think 4 strikes is the better rule, so the umpire should listen to this player. If that's your position, you're probably not an originalist, and I'm not going to be able to convince you. But some people do think that way. They think the umpire should do whatever is best. Other people are going to say, that's a bad argument. It's a terrible argument. The umpire should say no. And maybe that's where you are. But neither of those is the originalist impulse. The originalist impulse is that the umpire should ignore this argument. It doesn't matter if it's a good argument or a bad argument, because the umpire is not the person who decides how many strikes you get in the game of baseball. There's a rules committee. There's a baseball commission. These are the people who decide the rules of the game, not an umpire mid-season. That's not what umpires do. Umpires call balls and strikes. They get the inputs and they follow the rules of baseball reasoning, analogous to legal reasoning, to an outcome. They don't change the rules. If you want to change the rules, you have to talk to the baseball commission. Just like an originalist would say, if you want to change the constitutional rules, talk to your legislature. That's not what judges or justices do. That's originalism. Originalism seeks to preserve the constitutional order as enacted. It seeks to keep a fixed meaning of the Constitution because that's what judges do. They engage in legal reasoning and decide how the law applies to the facts. They do not change what the Constitution ought to say. So, with that little kind of warm-up, let's talk about the death penalty in America. And before I do this, I need to give you a disclaimer. I'm a member of the death penalty bar. I got a client off of death row in Texas. His name is Cesar Fierro. A lot of wonderful lawyers worked on that case. There's a documentary about him called The Years of Fierro. It's a wonderful documentary. You should look it up. In any event, I have a bias here. I'm flagging it. As an originalist, I'm going to hope to make it irrelevant, but I do want to flag the bias as we go into this conversation. So the question is, does the death penalty violate the Eighth Amendment? Now, there's a lot of law on this, and I'm not going to get technical about that law. I want you to imagine that you're on the Supreme Court and you are asked this question, and you're kind of working not on a total blank slate, but we don't have to get into all the nuances of the case law just to make things a little bit simpler. Well, let's look at why people might say the death penalty violates the Constitution. The most pertinent part of the Constitution is the Eighth Amendment, which says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. It's this last clause that people think matters, nor cruel and unusual punishments inflicted. People have come to the Supreme Court historically and said, the death penalty is a cruel and unusual punishment, therefore the Constitution bans it. Spoiler alert, the death penalty is allowed constitutionally in our country. There are limitations that were imposed on it in various cases, but again, we're not getting into that nuance. We're trying to keep it a little higher level. The question is, if this question is presented, is the death penalty unconstitutional? How would an originalist look at it, and how would a non-originalist look at it? Well, let's go back to this Scalia quote. Lawyers decide what a constitutional text means. They interpret the meaning, but they cannot be expected to decide. We cannot let them decide what it ought to say. That's what the people do. So the people, through their elected representatives, enacted the Eighth Amendment. They did this circa 1788. What that means is what it meant then. What did the people mean? This is an important concept because in a democracy, majority generally rules. If you get a majority, you can do what you want in a democracy, except if there is a constitutional right. Constitutional rights are limitations on democracy. If you want to limit the freedom of speech and you have 80% of the people who want to limit the freedom of speech, you still can't because the Constitution says you can't. If you want to violate due process, you can't because the Constitution says you can't. Your rights, your constitutional rights, are limitations on what the majority in a democratic system can do. They are limitations on democracy. Why does that matter? Because if judges get to decide what the limitations are, judges are the ones who decide what the limits of democracy are. And what Justice Scalia is saying here is that's not what judges ought to do. Judges ought to ensure that the limits that the people decided were appropriate are enforced, but they should not invent new limits. So, how would an originalist answer this question of whether the death penalty violates the Eighth Amendment? Well, they would say, what does the Eighth Amendment mean? What did it mean at the time it was enacted and ratified? Well, there's evidence of that. What evidence could you look at? Well, the first thing is there's other parts of the Constitution that were ratified at the same time. So we could look at the Fifth Amendment, which says No person shall be held to answer for a capital crime. A capital crime is a crime for which you can receive the death penalty. That's pretty clear evidence that the people at this point believed that capital crimes could take place, because they say you cannot be held to answer for a capital crime unless on presentment or indictment of a grand jury. So you can't be held on trial and potentially given the death penalty unless there is a grand jury presentment, with some exceptions. Nor shall any person be subject for the same offense to be twice put in jeopardy, the double jeopardy clause, of life or limb. You can't be tried for the same crime twice, and those crimes can include crimes where you are at risk of losing your life. Nor shall a person be deprived of life, liberty, or property without due process. You can lose your life as the result of a trial, but only if there's due process. So, did the people, when this constitutional provision was ratified at the same time as the Eighth Amendment, believe that you could lose your life as a result of a trial? Obviously, yes. They referenced it in the Constitution. This is not a hard case. So, does the Eighth Amendment ban the death penalty? No. And in fact, if you look at the history, every state at the time of ratification had the death penalty. So, from an originalist perspective, this is a very easy case. And notice that my policy preference didn't matter. It didn't come up. It's not part of the analysis. But there is an alternative to originalism: living constitutionalism. Living constitutionalism is the idea, and it was expressed very well in Trump v. Dulles when talking about the Eighth Amendment, where they said that the Constitution should draw its meaning from the evolving standards of decency that mark the progress of a maturing society. This is very sonorous, inspiring language. It makes you feel good to read it. It's a beautiful sentence. The idea there is that, well, okay, we know that people, when they ratified the Eighth Amendment, they allowed the death penalty, but society is changing and evolving. Shouldn't the judges read this language in light of today's standards? And in fact, they were very clear in a later case called Atkins v. Virginia, quoted below, where they said that the cruel and unusual punishment is judged not by the standards that prevailed in 1685 or when the Bill of Rights, including the Eighth Amendment, was adopted, but rather by those that currently prevail. The judges, the justices of the Supreme Court, are the arbiters. They look at society and they say, what are the standards that govern today? And we apply those to the Constitution, not the original meaning. This is inspirational. And prior to law school, this is how I thought. And it was very appealing to me, in part because it backed my political projects, and also because I liked the idea of wise judges thinking about what society is like and saying, oh, we really ought to be this way. And then in their wisdom, creating a new rule. It appealed to me. And it might appeal to you, and it appeals to a lot of people. So I want to give it its due. It is an appealing school of thought. I don't think it's correct, and we're going to get into why. But if anyone tells you that they support the living Constitution, and I think they're wrong. I think it's a bad idea, but it's not like there isn't an argument to be made. So what is the problem with living constitutionalism? Why is originalism better? I'm going to try to explain this in the course of a personal story. And the reason I'm doing that is to try to make this as accessible as possible and not to get lost in legal philosophy, which can often make these conversations impenetrable and then people just retreat to their own corners. So I invite you to go back to the time period of Obergefell v. Hodges, circa 2014, 2015. At this point, I was in law school. And when this case was decided, I was actually very fortunate. This is one of the perks of being in law. I was fortunate to be working in a foreign office in a summer internship, which was a wonderful gig. So I was in Paris, and I was sitting at a cafe when this decision was published, and I was unbelievably proud. So I have a lot of gay friends. I have gay family members. Many of them were, at that time, not allowed to be married in the United States. Some states allowed it, some states didn't. This case was to decide whether the Constitution requires recognition of gay marriage, meaning it's now the law of the land. And that is, in fact, what the Supreme Court did here. And I hadn't read the decision yet. I just read the news reporting, but I was over the moon. I was excited for my friends. I thought it was the right outcome. And I was very proud because I was going to become a lawyer soon. I was still in law school, but this was the profession whose ranks I was going to join. And I remember sitting there looking out. I thought I was the only American at the cafe, thinking to myself, God, what a wonderful thing my profession just did. And here I am, an American, feeling very proud of America and my profession and myself, and thinking this is just wonderful. I hadn't read the opinion yet, but the headline is, the 14th Amendment requires a state to license a marriage between two people of the same sex and to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state. So states cannot fail to honor gay marriage, and they have to provide certificates to people who want to get married in the state and honor gay marriages that were performed in other states. This is now the law of the land. The Constitution says so. The people in the states or in the federal government cannot say differently. Why was I happy? I was looking at the results only. I was not yet looking at the process. And as I said earlier, this is not a great way to evaluate legal reasoning or court cases in general. And I was about to get a bit of a rude awakening, and I'll explain to you why. Aubergefell was authored by Justice Anthony Kennedy, who retired in 2018, and it includes truly inspirational language. When you read it, there's a lot of very high-minded passages that make you feel good about yourself, and includes language like this. The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity. That's inspirational language. It doesn't actually have a lot of legal reasoning in it, though. It doesn't really explain how the 14th Amendment could be read to reach this point. And if you look at the 14th Amendment, and this is the pertinent part, Section 1, it says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. That doesn't seem relevant to gay marriage. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Maybe a law that bans gay marriages violates that clause. Maybe that's a privilege or immunity that can't be abridged. Okay, possible. No state shall deprive any person of life, liberty, or property without due process of law. Well, maybe marrying who you want is a liberty that can't be deprived, and there's something called substantive due process we can talk about in another video. It's a little much for this one. Maybe that applies. Nor deny to any person within this jurisdiction the equal protection of the laws. Well, that one seems on all fours. Maybe, straight people can get married, gay people can't, so they're being denied equal protection of law. These all seem plausible. But what does this text mean? Well, as Justice Scalia pointed out in his very famous dissent, when the 14th Amendment was ratified in 1868, every state limited marriage to one man and one woman, and no one doubted the constitutionality of doing so, which in his mind resolved these cases. What's he saying? When the 14th Amendment, the critical amendment for this case, was enacted and ratified, everybody understood it to mean that limiting marriage to one man, one woman was appropriate. So if you are saying the 14th Amendment means something else, you are engaging in living constitutionalism. You are saying the meaning that it had at that point is not the point. We are evaluating it in terms of the evolving norms of a living society where everything gets better and better and better. And these wise justices are going to interpret our norms and say, it didn't mean this yesterday, but today, this is what the Constitution means. Here's the problem. As I mentioned before, constitutional rights are restrictions on the democratic process. When a judge decides the Constitution means something today, it didn't mean yesterday, and it is limiting the democratic process without the people getting a say-so. The people are the ones who ought to say what our rights are. The people are the ones who ought to say whether or not we are allowed to do something in a democracy. If you love gay marriage, get a law passed. If you don't love gay marriage, get a law passed. Or get a lot of momentum and amend the Constitution. But when judges do it, it is anti-democratic. It is taking democracy and limiting it. It's saying that this is not an issue that democracy can decide. The people are not allowed to vote on gay marriage. It is not up to them. It is up to the judges of the Supreme Court, even though the Constitution does not say anything about gay marriage, and the provisions of the Constitution that the court relied on were understood to not have anything to do with requiring gay marriage at the time they were ratified. This is a thing the justices of the court, the majority, are now putting into the democratic process as a limitation of their own invention. The problem here is not the policy. It's not about whether or not gay marriage is good or bad. The problem is justices reaching out and seizing control of the democratic process. And this is a portion of Justice Scalia's famous dissent. It was one of my favorite pieces of legal writing, and it's the one that really convinced me that originalism is the way forward, even though I, as I said, favored gay marriage. I read Justice Kennedy's opinion. It was sonorous, it was wonderful, it had beautiful language, it was inspirational. It did not convince me through legal reasoning that the 14th Amendment did what he said it did. It really read more like he thought it was a good idea. He thought it was the right thing to do. And here's what Justice Scalia said about that. It's a lengthy quote, but it's worth reading. The substance of today's decree is not of immense personal importance to me. The law can recognize as marriage whatever sexual attachments and living arrangements it wishes, and can accord them favorable civil consequences from tax treatment to rights of inheritance. Those civil consequences and the public approval that conferring the name of marriage evidences can perhaps have adverse social effects, but no more adverse than the effects of many other controversial laws. So it is not of special importance to me what the law says about marriage. He's saying this is not a policy issue. He's not saying I disfavor gay marriage and therefore I oppose this ruling. He's saying in a democracy, people can do anything that the Constitution allows them to do. And if they want to honor gay marriage or not, that is up to them. He might not think this is a great policy, and maybe it will have bad outcomes and maybe it will have good outcomes. But policy disagreement is not a reason for a Supreme Court decision. They're not the Senate. They're not the House of Representatives. They're not the Congress. They are not meant to decide the policy. They're meant to interpret the law. And that's all he's saying there. It's a policy. It might not be his favorite policy, but the fact that it's not doesn't really matter to him that much. What does matter to Justice Scalia? It is of overwhelming importance, however, who it is that rules me. Who decides what the limits on democracy are? The people or the majority of the Supreme Court? Today's decree says that my ruler and the ruler of 320 million Americans coast to coast is a majority of the 9 lawyers on the Supreme Court. The opinion in these cases is the furthest extension, in fact, and the furthest extension one can even imagine of the court's claimed power to create liberties that the Constitution and its amendments neglected to mention. And you see, he put liberties in scare quotes. Why? Because when the court invents a right, it is inventing a restriction on the democratic process. The question is whether you think that's appropriate. This practice of constitutional revision by an unelected committee of 9, always accompanied as it is today by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, the freedom to govern themselves. The question Justice Scalia is asking is who rules you? Is it the elected officials, the senators, the congresspeople, the president that you elected through the democratic process? Are they the ones who decide what our law and policy are going to be? Or is it the majority of an unelected Supreme Court? And I submit to you that under originalism, justices are humble. They seek to keep the rules the same. You might like or dislike that outcome, but that process is understandable. They are seeking to keep the rules the same, and if the rules are going to be changed, they will be changed through the democratic process, not through judges looking into their crystal balls and saying, what policy preference do I prefer? What do I think is best for society? And I'm going to give you a hint as someone who served as a clerk. Judges are the least well-positioned branch of government to decide what the norms of society are. That's why we have elected representatives, because they're responsive to the people. Judges have lifetime appointments, they are not elected, and their job is not to be in touch with the people, but to understand and interpret the law. If we ask them to be crystal balls of public opinion, we are asking them not to act as judges using legal reasoning, but as amateur sociologists, amateur pollsters. This is not legal reasoning. This is not what judges do. Who rules you? Your democratically elected officials or unelected judges? And that's the case for originalism. Maybe I convinced you, maybe I didn't. Either way, I hope you got something useful out of this. I would love to do this again. This was a little bit of work for me, but I think a lot of that was because I'm unfamiliar with putting up content like this. Hopefully I can do more in the future. Here are some ideas of things I thought might be interesting to talk about. The proper role of each branch of government, the frustrations with Congress and its gridlock and why it never seems to get anything done, and what that means in terms of our constitutional order, the importance of local government and our federal system, and the ongoing effort to rebrand living constitutionalism. Justice Scalia popularized originalism to the extent that living constitutionalism is a bit on the back foot, but there is an ongoing effort to repopularize living constitutionalism through a rebrand, and we can talk about that, or other things. Let me know in the comments. I'd be delighted to talk about what interests you. I hope that this was useful. I hope it gave you a sense of the arguments, and I hope it was accessible. If you agree with me and you think originalism is the way to go, that's fantastic. Please let me know. And if you think that originalism is an absolutely garbage philosophy and you have reasons why, let me know as well. Hopefully I helped you sharpen your arguments. Till then, this is Ryan Mullally. As always, questing for natural law. Talk soon.